Yes, good evening to the students of the Advanced Private International Law. Karibu sana, welcome to the class. And yesterday I dealt the conflict contract. It is some part of it we did it. And we will continue after just a small bit. I got it, the law of trust. How the law of trust would be there and how the conflicts in the trust will be resolved. Let us see this one. Now, the private international law issues in the law of trust. Of course, this is one of the theses there, and the abstract is given that give the gist of it. The aim of this thesis is to examine the private international obstacles arising issues in cases of involving trust. Where the trust is involved over there, at that instance, how the conflict could be resolved. When you see actually the trust, it is nothing but contract. A trust is formed for the sake of the beneficiary. The trust members should be there. And the members will, trustees, we can say the members of trustees will take care of this trust and see that whatever the trust benefit would be there, that will goes to the beneficiaries. And the trust property cannot be alienated unless until the court permissions be taken. This is normal principles, general principles of trust. This means that particular case involving the trust must also include a foreign element. Yes, because private international, when you say, definitely foreign element is there. Is it or not? Say, without the foreign element, it will not be called a conflict of laws. Do you agree?
Yes,
Remember,
sir.
so a
Yes,
foreign
sir.
element in such a cases, the lex fori must go through certain procedures in order to decide a particular case. So, lex fori, law of the forum, and certain procedures should be followed. Regarding the procedural law is concerned, we will follow the law of the forum. Regarding the substantial law is concerned, it depending upon the nature of the case and the parties agreed for that one, it will be decided. So this thesis commences with an introductory chapter including the various definitions of trust. Of course, trust definition they have dealt it, and the discussion of the common law, trust development to the civil law jurisdiction, and how the common law plays an important plays the role in the trust jurisdiction, particularly in the Maltese system. And here he has emphasized the Maltese system through the introduction of the fiduciary obligations in the civil code. When you see the civil code, there is a fiduciary obligations are there. But when you say the Tanzanian case law, do you have a separate trust law in Tanzania? A law of the trust?
I'm not sure, sir.
Because
I never come up.
a trust is formed based on the contract itself. And for the formation of the trust, I don't know whether it should be registered because is it like a company or industry? So we'll see it how a trust under the Tanzanian law. But we see how it can be made. This chapter gives a brief overview of the private international issue general and goes into the detail on the preliminary issues of the choice of law falling outside the Hague Conventions on which are determined case. Once the forum court has decided, it has a jurisdiction to hear and determine the case at hand. So now, which court is having the jurisdiction? It depends upon the where the trust is formed and what are the terms of the condition of the trust. And the Hague Conventions deals with the contract law and also the various other aspects also the Hague Conventions having the say. So let us see the second chapter deals with one of the most important private international law questions concerning the jurisdiction of the court seized with a case of involving the foreign element and trust relationship. So this chapter includes the relevant article relating the trust of the Council regulations applying the cases of involving the member state of the European Union. Of course, the member states of the Union for the Europe and the member states of the Africa and member states of the Inter-American Court. We can say tribunal or court, Human Rights People's Court. This chapter includes the relevant article relating the trust of the Council of Regulations. Of course, this is the Council Regulations. I believe it is an international instrument, it seems, applying the cases involving the member state of the European Union as well as the Maltese law under the Article 742 of the Code of Organization and Civil Procedures, more specifically the trust. Article 8 of the Trust of the Trustees Act. Any Trustees Act, if it is there, both applying when a particular case falls outside the scope of the council regulations. If any council regulation outside it will falls over there at the time, the country trust law could be followed. Of course, this is said. Then the third chapter deals with another crucial and vital part, international questions relating the choice of law, which leads to the applicable law or a governing law to be applied to the case at hand. As I told you clearly, trust is nothing but formed on the principle of the law of contract. So in the law of contract, and we studied yesterday, choice of law is there, even though the parties not belong to the particular country, because they have chosen the choice of law of a particular country because the country law is well developed, and hence party will choose such a law. Therefore, this chapter goes into the detail with regard to the article of the Hague Conventions as are ratified and attached to the Trust and Trust Act. So, there is a Hague Convention should be there regarding the trust, and let us see that whether we have a Trust Act in Tanzania. Now we will see it. I will Google it. Significant examination of the express and implied choice of law rules as well as the governing law in the case of the absence of such express and implied choice of law is made. Like if the choice of law is not there, then naturally we will follow the correcting factors and we follow the international instruments and how far the municipal law would be domesticated. Based on it, we will decide the case. But in any case, when it will be decided, generally the state party law could be used. Domestic law would be used. The fourth chapter devolved into the limits to the application of the governing law as provided under the Hague Conventions and the recognition of the trust falling within the scope of the Hague Conventions. So trust should be recognized under the international instrument, that is the convention, the Hague Convention. The latter being the second main function of the Hague Convention, and this chapter also deals with the recognition and enforcement of the foreign judgment under the Council Regulation of the 44/2001, distinguished from the recognition provided under the Hague Convention. See, in the trust also, there are cases. When there are cases would be there of the foreign country, at that instance, can we recognize and enforce such a foreign judgment? Again, the question is, it depends upon the state parties are there. If there is any charter is there, or if they are the members of a particular state, or charter, or a treaty, at that instant, definitely. But when it is not the member state of a particular charter, then how can we implement it? Then the question comes is the theory of obligation could be taken. If the theory of obligation will be failed over there, then the reciprocity, that is the doctrine of comity could be applied over there. The same thing, law of contract that we do it, and the same manner for the trust also will follow the same law of contract rules and regulations. As distinguished from the recognition provided under the Hague Convention, the conclusion provides reader that the question as to whether the European and international movement towards the harmonization of the private international law issues relating the trust have simplified to further complicated the private international law process in cases involving the trust relationship. See, we also saw unification of the private international law, and we try to make the harmonization of the rules depending upon the member state and where they are the member of the charter or the member of the treaty. So trust law definitely will follow it, and their law of contract, all the rules and regulations, connecting factors, a choice of law, lux causa, a recognition, enforcement of the foreign judgment, and which court is having the jurisdiction to entertain such a case. It is clearly mentioned in the trust then there is no dispute at all. But when the choice of law is not there, when the jurisdiction is not made clear, at that instance, we follow the norms of the trust of the international. And as I said, the Hague Convention also made the attempts to harmonize the Trust Act and see that the Trust Act will be prevailed in friendly manner with all the states, no, without hurting the sovereignty of the state. So, when you say the trust, it's nothing but the one of the form of a contract. Is it clear?
Yes, sir.
So that was the thing which I want to share. And another, I found a beautiful some of the notes. This also I will send to you, and let us see whether he has made on contract or not. Control file. Okay. Whether he made under the contract. Because we saw yesterday another handout where we discussed about the contract. Yeah, the same thing will be there. Comedy theory will be applied, and these are all the connecting factors. These are all the connecting factors. Did you see it? Lex citus, lex fori, lex loci actus, lex loci celebrationis, lex loci contractus, lex loci delictus, lex loci domicili. These are all the what are they? These are all the connecting factors. So let me see that conflict cases, how they solving the conflict loss problem. Factors, points of contract, connecting factors, element of characterization, we studied element of characterization. And when it comes to the matter of the trust, what they say? Legal capacity, law of the place where the contract was entered into. Yes, we have thrown light on this also yesterday. Philippine law, is it not? Is it not?
Sir, I don't think if yesterday we passed on this
No,
one.
this we did not do yesterday. This we did not do yesterday because now I got this new. This is a new one, but we'll discuss it tomorrow's. I will find it out because my old computer is Imbovu Kidogo. Problem is there. This is a new computer, so I could not open the fully what we discussed. But I can make it out from your WhatsApp. Because I posted to you in the WhatsApp. Did I post to you in the WhatsApp yesterday?
No, we didn't find any document yesterday, no,
Acha,
sir.
acha, acha, acha. Yeah. It is with me only. Yeah. Let me check it. Where did you find it? That thing. Trust, private intentional law, trust property. Okay, this is the different cases. Now I will find it out by opening the. Yeah. This is the thing which you did yesterday. Okay, let me scroll it. Let me first save this one so that it will not be problem. It will not be problem to us. I don't know where it is gone. Yeah. Okay, let me scroll it. Then we'll see. It starts from 22nd page, if I not be mistaken. 22nd page means still we are ninth only. Yeah. We will scroll down. And because in yesterday that we dealt with the contract of law of the parties, no, this we did not 22. This is 17, again 19. Okay, now we got it. '21. This is a different. Because we made it from 22, I think. Okay, let me come to this point because yesterday's class, then we'll I find it from the place, then I will make it out. Let me see what is the oh no, it's the fourth one it is given because fourth one is the contract. Because we came, yeah. Did you get it? The same thing that which I printed. Is it or not? Contractor, like see contractors, we dealt it, and contract is the law of the parties, and Philippine Overseas Corporation NLRC will not be followed in the another law we discussed, and exception with the contract with public policy, Pakistan International Airlines Corporation versus Opal Air, and there we are discussing the thing. So here the Pakistan International Foreign Corporation license to do business in the Philippines executed 2 contracts of employment with the private respondents for their services of flight stewards. The contract had a term of the 3 years, but with the stipulation that notwithstanding any provisions to the contrary, the employer reserves the right to the pre-terminate it if any time before the expiration of the 3 years term. Pakistan International sent a notice of dismissal to the private respondents, prompting them to file a case for the illegal dismissal and recovery of the wages and other benefits. So issue is whether or not the situation in the contract as to the right of the employer to terminate the employees at any time should be respected. Supreme Court held that in the negative manner. And if there I am given the example, a employee can be terminated at any time without giving the notice and without any reason. Suppose such a contract, such a stipulation is there in the contract is voidable and void also. Because it is against to the natural justice. Is it clear?
Yes, Professor.
Okay. What is the natural justice? You could hear both the parties. Then only you can come to a conclusion. Means a chance will be given to the other party to defend himself or herself. What is the maxim is there? Let you hear both the
A
sides of
right
the parties.
to be
What is the maximum? Administrative law
a
maximum
right
is
to
there.
be heard.
Repeat.
A right to be heard.
No, Latin terminology. Adi altrum partem. Have you heard this one?
Yes, Professor.
Adi altrum partem. That is, of course, the right spelling. We will see it. But let you hear from both the parties. Then you can take the decision. See, if a student comes late to the class, you are not supposed to punish him. What you have to do? You ask him for the reason for the late. If the
Yes.
reason seems to be genuine, naturally you should not punish. But if he came late, punishment should be there. He should not be there. It is against the natural justice. And allow that student to say why he is late. Okay?
Yes.
So here they said a contract freely entered into should be respected. But that contract is not freely entered because there is no both the side defense will be given. It is not there. At any time, an employer can terminate without any reason, without giving a notice. No. So his a contract freely entered into should be respected. Whether such a contract is freely entered by the employee because he wants the livelihood. Otherwise, he will starve to death. So he will accept it and he will sign it without thinking. But when you go to the court, court will definitely ask. The consent is not given with the free consent. And since a contract is the law between the parties, the principle of party autonomy is contract is not. However, the absolute principle, the rule in Article 306 NCC that the contracting parties may establish such a stipulation as they may deem convenient. See, the word is deem convenient, provided they are not contrary to the law and morals, good customs, public order, and public policy. And yesterday we discussed. It should not be contrary to the autonomy, nor contrary to the principle of the parties, the customs and good customs, morals, public order, and public policy. Thus, counterbalancing the principle of autonomy of contracting parties is the equally general rule that provision of applicable law, especially the provisions relating to the matters affecting the public policy, and deemed written into the contract. So, put a little differently, in different manner, the governing principle is that parties may not contract away applicable provisions of law, especially preemptory provisions dealing with the matters heavily impressed with the public interest. If any public interest is hurt, or public policy is hurt, or morals are hurt, or contrary to the law, or contrary to the public policy, yes, that cannot be a law, and it can be said as a void law by the court. The law relating to the labor and employment is clearly such an area, and the parties are not at liberty to insulate themselves. Because employer is having the higher bottom level and the employee is having the lower bottom level. At that instance, employer try to make the employee to accept the contract, employment contract. So that is called adhesive contract also, standard form of contracts. At that instance, you don't have any say because already is printed over there and you have to sign, that's all. So their relationship from the impact of the labor laws and regulations, but simply contract with each other. So when a contract is made with the not the free consent of the employee, at that instance, court will definitely consider, yes, it is not freely given the opportunity for the employee to say something, and because the employer is having the high bottom line and the employee is having the low bottom line. So that is the thing. Suppose if there is no agreement on choice of law, if there is no express contract, the court of the forum will apply any of the contract law rules, such as the lex loci celebration is. If the no choice of law is there, at that instance, in the case of the marriages, what we do? Lex loci celebration is. In the case of the contract, lex actus. In the case of the tort, they will say lex delicti. They will apply that theory. So, it is again Bangong, Philippines, overseas versus supra case law, state of the most significant relationship theory will be taken into consideration. Most significant relation to theory. I told you yesterday, a contract is made between the two parties, one party from India, another party from Tanzania. Where the contract is made, it is made in India. That is the lex loci contractus. But the contract should be executed where it will be executed in Tanzania. Is it clear? Okay. Now if any contract comes, which country law will prevail in case of a breach? Tanzanian law or the Indian law? If it is not agreed in the contract, if it is not clearly agreed in the contract, at that instance,
Lex loci.
please say, Raymond,
Lex loci contractus.
it is only the formality would be fulfilled over there, Indian. Lex loci contractus. A formality. What are the formality would be there for the contract that will be made in the India? Okay, that is clear. But the lex actus is the contract will be executed in Tanzania and the breach is made in Tanzania. And the another party is a resident of Tanzania, citizen of Tanzania, domicile of Tanzania, and he is having a only right to forum convenience to him only in Tanzania because he is having the business in Tanzania, but he went to India to sign the contract. Is it clear?
Yes, sir.
At that instant, the substantial law is Tanzanian law. When it is not made clear which country law would be followed in case of a breach, then we will follow this. Suppose if you, I don't know whether you have seen the South prospectus or not. There would be prospectus, there is a provision is there. If any dispute would be there between the parties, then Mwanza jurisdiction only having to file a case because South is in Mwanza headquarters. Only Mwanza court is having a jurisdiction to entertain any case, either student versus university or staff versus university or any other thing is there, then definitely only Monza court is having jurisdiction. They clearly mention there. Then suppose the student is from, say, about Botswana or Burundi. At that instance, he cannot file a case in the Burundi because he has accepted the jurisdiction of the Monza. Is it clear?
Yes, sir.
So, no agreement or treaty, what we say, the plaintiff makes the choice of the forum, definitely, or the court where the action or complaint is filed, okay. In Saudi Arabian Airlines, in the above which is given, there being no choice of law clause in the employment contract, the plaintiff chose to her case before the court of her home country and the Philippine court and applied the state of the most significant relationship theory to resolve the case in her favor. In the above case law that we say that where he died is not the criteria. Wherever he came from and which is the forum shopping for him, that is a criteria and that country law would be applied. That's a lex 4E law would be applied. Law of the forum would be applied. So for the getting the compensation. So now let us see the lex loci contractors are a place of performance. So the law of the country where the contract is to be performed generally governs the liability for the breach of contract by the obligator to perform this part of the obligation. Where it will be performed, generally that country law is having the more dominating power. Place of contracting versus place of performance. Place of contracting means where the contract is wind up or made. Just before that, I gave the example, a Tanzanian and Indian, and Tanzanian went to India to sign the contract. That is the place of contracting. Is it clear?
Yes, sir.
And I told you, the contract should be executed in Tanzania. That means place of performance is place of performance of the contract is
Tanzania.
Tanzania. So now, if any dispute comes, whose country law would be applicable? Law of the forum. Tanzanian law. Because in the contract it is not clearly mentioned. So what is the connecting factor? Where the contract will be performed. The facts, let us see the one of the case law, that the 888 integrated service and NLRC. Here, Osdana, a Filipino citizen, was recruited by a 888 for the employment with the latest principal, Gulf Catering Company, a firm based in the Kingdom of Saudi Arabia. The employment contract originally as a food server, but later changed to the waitress, then was executed in the Philippines, but was to be performed in the Riyadh. Once the Riyadh, however, the Osdana was made to perform the strenuous task, washing dishes, janitorial work, which were not included in her designation because she is a waitress and food server. At that instance, he cannot be taken work as a janitor or washing dishes, which were not included in her designation as a waitress. In time, she developed a carpal tunnel syndrome. It's one of the disease for which she had to undergo the surgery and a weeks of the hospital confinement. But when she returned to work, the GCC informed her of her dismissal, allegedly on the ground of illness. So, because when she was washing the dishes and janitoring, she developed a disease called carpal tunnel syndrome. Because of that, she was hospitalized and she has undergone the surgery. So, she was admitted in the hospital and she was confined to the hospital. And when the absence of this, her absence, they who employer dismissed her allegedly on the ground of illness because the groundness of illness we got over there and hence he was dismissed. But generally, when people go to the hospital, they will inform, they produce a medical certificate stating that they need the rest or the treatment is going on. But here, abruptly, they say when she did not turn up to the job, then the employer dismissed her. So, issue is whether or not Osdana was illegally dismissed from the work. See, whenever a person is ill, naturally you cannot force him to work or cannot force her to work. Better you will be given and refer the referral hospital for his health. So held there was a illegal dismissal because for human being there is a probability that a man will get the illness. Do you agree? Do you agree? Say yes.
Can you repeat, sir?
And at that instance, sometimes they will not inform, sometimes they will inform because of the emergency. So GCC argued that the requirement for the medical certificate from the Public Health Authority was physically impossible to comply with the since Osdana was employed in Saudi Arabia and not in the Philippines. So there was no way for them to get the eluded medical certificate from the Philippine public authority. But Supreme Court held that the rule simply prescribes a certificate by a competent public authority and not a Philippine health authority. Also, the argument that the Saudi Arabia laws should apply is not obtaining established in the rule that lex loci contractus, the law of the place where the contract is made, governs in this jurisdiction. There is no question that the contract of employment in this case was perfected, heard in the Philippines. Therefore, the labor court, it's implementing the rules and regulations and other laws affecting the labor apply in this case. Furthermore, settled in this rule that the court of the forum will not enforce any foreign claim obnoxious to the forum's public policy. Now the question comes, without showing the reason if the dismissal is there, it is against the natural justice. Okay, matter comes to the producing the medical certificate. Where she admitted, from there she can produce the medical certificate. Yes, if the medical certificate proves over there his absence or her absence, then it is a valid ground, and the employer cannot dismiss based on the illness. Is it clear?
Sir,
Yes.
I have a question. I try to construct the place of celebrationist and the place of performance in this case and in this scenario. So I failed to connect it. So can you please help us?
Yes. Lex loci celebration is applicable only for the marriage. Lex loci contract is applicable only for the contract. At that instance, where the contract is performed, being the lex causae, because there is a conflict, there is a breach happened in that place where the work is in progress. At that instance, that place country law could be applied for the substantial law. Regarding the procedural law, I told you where the contract is concluded, that procedure would be applied in that country. But the performance is concerned, where the breach occurred over there, their law would be applied as a substantial law for the compensation. But lex loci celebration is applicable only in the case of marriages, where the marriage is solemnized. That country law would be applied. Is it clear? Is it clear?
Yeah, it's clear now, sir.
Lex loci celebration is only for the marriage. Lex loci contractus, lex loci actus. This is only for the contract. See, the Warsaw Convention, otherwise known as a
Sir,
convention for the. Yes, please.
sorry, sir. And
Yes.
please, before you continue,
Yeah.
in the contract,
Yeah.
I try to look on the difference of where the contract was made
Yeah. Yeah.
and where the contract
Is
performed.
performed. Okay. Okay.
Yes.
Now we will go to the connecting factor. In the connecting factor, it clearly mentions. See here, lex loci actus. Did you see it? Did you see
Yes.
it?
Sit.
Here, 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 here.
Yeah.
Lex loci actus means the law of the place where the act is done. Which act? Completion of the contract act. Completion of the contract.
Contract.
Okay. Now,
Okay.
lex loci contractus will let us see. The proper law applicable in deciding the right and liabilities of the contracting parties. That means place where the contract is executed or the
If the
place
same
the contract is performed.
executed.
Is it clear?
Okay.
So that
Yes,
is
it's clear.
when you come to the lex loci celebration is the place where the contract is entered into. Celebration is here means marriage also celebration, solemnizing.
Okay. Okay.
Actually, it is also a contract, is it not?
It is.
Hence,
So I was trying. These three was just confusing, but now it's clear.
celebration is especially family law, matrimonial matters.
Okay.
And the actus is only the place where the contract is concluded, made. And the lex loci contractus means place where the contract will be performed and applicable law deciding the rights and liabilities. When the breach happened in Tanzania, so Tanzania government will give the rights and liability to the party. Is it clear?
Yeah. clear now, Professor.
Okay. Now you know the domicile, lex loci domicile. It is only applicable to the mobile property.
Yes.
Lex loci rate situs, the lex site is applicable only to the
Where a
immobile
thing is situated.
property. Is it clear?
Yes, sir.
Now here Kilberg Doctrine, because we did not study this. Kilberg Doctrine, what the doctrine says, a rule to the effect that the forum is not bound by the law of the place of injury or death as to the limitation of the damages for wrongful act, because such rule is procedural and hence the law of the forum governs the issue. Law of the limitation will not work in the private international law, because a right cannot be extinguished, not distinguished. A right cannot be extinguished, but the remedy will be barred because of limitation. Is it clear?
Yes, sir.
Right is definitely, right will not, right like a energy, it cannot be kufa. And law of limitation, it is only curb the remedy. So that's why you say law of limitation will curb only the remedy but not the right. Law of limitation will stop the remedy but not the right. Is it clear?
Yes, sir.
Good. So that was the distinction between the two. So now let us go to back to the Warsaw Convention, what it says. Yeah. Oh, we passed so much. No. Still there is there. Because we are there, the contract fifth, let's the rule and contract. Yes, we got it. Warsaw. We are dealing with the Warsaw now. Yeah, the Warsaw Convention. F. The Warsaw Convention can also be known as a unification of certain rules relating the international transportation by air, which took effect in the February 13, 1933, where there is a treaty or a convention to which the Philippines is a signatory, and where an action coming within the purview of such a treaty or convention may be filed, the plaintiff must follow the provision thereof on the matter. Now let us see. Limited liability of international carriers. Limited to US dollars 20 per 2 kilo unless higher value is declared in the advance and corresponding additional charges are paid. In the luggage, only for kilo 20 as a penalty, as a damages will be paid. Suppose if the luggage is lost, unless until it is made clear in the beginning, when it is booking, then the amount will be increased. So advance and corresponding additional charges are paid when there is a beforehand, there is an agreement at the time of the booking. So otherwise we'll get the only $20 US dollars per kilo if the goods are lost. So exceptions, when the airline itself is at fault. Yes. When the airlines itself is at fault, when the airline or its employee commit a wrongful acts or negligent, when there is a waiver on the part of the airline, when delay is caused by force majeure. Force majeure means act of God, means, or we can say vis major. It's the common law terminology. Force majeure is a civil law terminology. And the airlines is guilty of the neglect or malfeasance even if not negligent, airlines is still duty bound to ensure the comfort and convenience of the stranded passengers. So these are the points would be there. Then only you will get 20 USD for the loss of the luggage per kg. So that was the Warsaw Convention very clearly mentioned. But nowadays, you will get the electronic ticket. But earlier, did you see a ticket consisting of 4 up to 5 pages? And there, the ticket behind is with the small letters. All the conventions are mentioned over there, limited liability conventions. And there you will see Warsaw Convention also. But now the tickets we cannot say. But there is a disclaimer clause would be there where the limited liability will be mentioned, even the electronic ticket also. But earlier it is a ticket with the printed form is there, and there clearly written in the each page the liabilities. For the injury, for the death, loss of luggage, it's clearly mentioned. And limited liability of the carriers. Warsaw Convention is a constitutional place of destination. Of course, case lies place of destination versus agreed stopping place where action for the damage may be filled. See, place of destination. Suppose if you purchase the ticket in Germany and you are going to the USA, and if any accident happened in the USA, can you say that Germany law would be applicable or American law would be applicable? Tell me. Yes.
It will be governed to the.
Ticket
It will
is
be
purchased in
governed.
Germany.
Yes, sir.
And the plane registered in the USA. And the accident happened or mishap happened or offense happened in USA. And the person is German. So choice is given to him to file case in the USA or in Germany because forum shopping. The court will give the freedom to the plaintiff to file a case wherever he likes. Now he filed a case in German. Can German law would be applicable for the damages or USA law would be applicable for the damages?
Yes, sir.
Say which law would be applicable?
USA.
USA. Reason is most significant relation with the state where the offense was committed or happened. Committed is the correct word. A injury is committed. A tort is committed. Lex loci. Lex loci. Delicti.
Delicti. Yes.
Another is most significant relation with that state. That is
Is
the
in
other thing.
USA.
So the USA law would be applicable over there. So now the question is whether or not Article 28(1) of the Warsaw Convention in accordance with the Constitution so as to deprive the Philippine court jurisdiction over the case. So here they said the law where the most significant relation